Hi everyone, I hope everybody's feeling refreshed. I'm Advocate Apurva Mehta Ponerkar. I'm partner with A&B Legal, and our discussion today is going to be on the burning topic of criminalization of seafarers. And my esteemed panel here is Mr. Hari Narayan. He's a partner with United Maritime Law Chambers based out of Kerala. And Catherine Baddeley, who is a partner with Preston Turnbull. She has come all the way from London for us, and we will all be discussing the cases on criminalization and the guidelines that have come into force, which talk about various aspects of how this sensitive issue has to be handled. So everyone is aware that shipping is not without incidents, and fault or human error is always the focal point of such incidents. Presumption of fault is more often than not always presumed, and unless you prove it otherwise. Unfortunately, for seafarers, it takes the color of criminal prosecution and harsh penalties. And that is where the topic of criminalization of seafarers and their treatment during these criminal prosecutions takes the forefront. I think what more often than not happens is that people, they tend to forget the difference between actual fault of the seafarers, which has to be proved only through a long drawn trial. And meantime, the seafarers have to face rigors of the criminal justice system of the country in which they're undergoing such a situation. So everybody knows nobody wants to meet or have a taste of the police machinery of any state. And we lose sight of the fact that these masters or crew members are just professionals who are doing their daily jobs and unfortunately have to undergo a lot of stress when it comes to criminal prosecution. And they may not be mentally or physically be able to handle this stress. We have a lot of laws already in place, including our Indian Penal Code that talks about criminalization and imposes penalties on seafarers. And this has been there for ages. But how it is executed is something that has been taking center stage for quite some time now. I'll hand over the mic to Kate now, and for her to share the cases that she's handled and her firm has handled, and also how English law, what penalties and what offenses are available under English law for seafarers, and the protection as well.
Perfect, thanks very much for that. For those of you that were in the talk earlier, I set out my background. I'm a lawyer, a dry shipping lawyer predominantly at law firm Preston Turnbull. We're London-based, just deal in shipping litigation matters. But whilst my background is dry shipping, I've got some brilliant colleagues on the wet shipping side, and they're regularly instructed on cases that arise out of maritime incidents. We've also got a number of in-house master mariners, and those are our colleagues who, when we're instructed on a collision case, say they're first on a plane, out helping clients, evidence gathering, investigating, if they're acting for owners, taking early witness statements when everything's fresh in the mind. So I've spoken to them about various cases that the firm's handling. By way of example, one involves an incident in Taiwan. The vessel got into trouble outside port. It started listing, it wasn't clear why, taken on water. So the master sought refuge in the nearest port, but was denied access, presumably because there was concerns that the vessel would sink and cause an obstruction. Salvors were appointed, but they weren't allowed to go and attend the vessel. And as a consequence, she subsequently sank. All the crew were arrested. And it took 3 months to persuade the local authorities that a number of this crew could not have had any fault at all. So the likes of the cook was detained for 3 months. And even when the majority of the crew were allowed to go home, it was a year before the master and the other senior officers were allowed to leave. Obviously that's an incident that occurred outside the UK, but incidents do occur in UK territorial waters as well. And there are offences in place that are aimed at seafarers specifically. And this isn't new. They're currently consolidated into Merchant Shipping Act of 1995, but that is a consolidation of a previous act from the 19th century, and that itself kind of sweeps up offences that were already in place. So criminalisation of seafarers isn't new. The section 58 of that act provides that it's an offence that for certain acts or omissions to preserve that arise from conduct which endangers ships, structures, or individuals. So where the seafarer hasn't acted or has done an act, and there is a loss, or there's likely to be a loss, and the act was deliberate, or it was a breach of duty or a neglect of duty, or they were under the influence of drugs or alcohol, that's an offence. And that can carry up to 2 years in prison as a fine, or you may face both. But if you're in the UK, then you are subject to all UK laws and all UK criminal laws. So you may be familiar with the collision earlier this year of the Salong and the Stena Immaculate that happened off the northeast coast of the UK. That happened on the 10th of March this year. Unfortunately, during the collision, a seafarer was missing. He's presumed dead from the Salong, and the Salong captain, 4 days later, was charged with gross negligence manslaughter. So that's an offence that carries a maximum life, though usual is kind of 1 to 18 years. The trial for that master is due to take place in the new year, and we wait to see what happens.
Thank you, Kate. India has also seen a fair share of maritime casualties and thereafter criminal prosecution of the master, crew, and of course the owners. I'll let Hari speak about Indian laws and his experience in handling criminal prosecution of seafarers.
Hi, Apurva. Good evening. As you all know, criminalization can happen for two reasons. One, when the seafarer does something intentionally. That is something which we cannot do anything about, and the law will take its own course. The second is when a maritime casualty occurs or an environmental disaster happens. So even the crew, without knowing anything about the incident, they are implicated in a criminal action. I will give you an example of a case which we conducted a few years back. You can see the trauma that is faced by the seafarer in pursuing litigation in India. This was a case which went all the way up to Supreme Court, and then the entire crew had to face trial for almost 4 years in this country. This vessel was intercepted by the Coast Guard near to Tuticorin port on getting information that the vessel was carrying arms. Immediately the vessel was seized and all the crew members, including 25 foreign crew, were arrested and charged for the offense under the Arms Act and also for the Essential Commodities Act. Fortunately, all the crew members were released on bail, and then they had to face the trial. This vessel was actually a floating armory or a anti-piracy vessel, which is involved in anti-piracy operations. So how they operate is, they have two vessels, one on point A and one on point B. And those merchant vessels which require armed guards, security guards to be deployed on their vessel, will take the guards from point A, and once the vessel passes through the high-risk area, they will disembark at point B. So this is how they do the business. And most of the time, the vessel was in international waters. It so happened that the vessel ran short of fuel, and it started drifting towards the shore, and it touched the territorial waters. So that is when the Coast Guard intercepted and arrested all the crew for holding arms. This was an American vessel of course, flagged. The owners are Americans. The vessel was flagged with Sierra Leone. So in America, there is no need to have a license to hold arms. So they were carrying these arms and engaged in the business of combating piracy. So the first argument that we raised for the owners as well as the crew was that the act of the vessel and the crew was intended to fight piracy, and which is protected under Article 100 of UNCLOS, which says that the state has to take necessary steps to combat piracy. And since the vessel was in a distress condition, it coming to the territorial waters was also something which is protected under UNCLOS. You all know Article 17 permits innocent passage. So if a vessel is stopped as part of its passage, that is also saved under UNCLOS. So both these points were argued before the Madras High Court, which found in favor of us and quashed the entire charge raised against the crew members. But the state government took up this matter in appeal to the Supreme Court, and Supreme Court reversed the finding of the High Court, holding that these are all questions of fact. Whether you're holding arms with some intention to fight against the nation or something is something that can be realized only after going through a trial. And on that basis, the Madras High Court judgment was reversed and it was sent back to the trial court for fresh trial. And then the crew had to wait for another 3 years, and ultimately they were all released, holding that no charge will lie against them. So what I tried to point out is, even the highest court of the country was not able to understand the concept of fighting against piracy. Just because of the fact that charges were framed under the Arms Act and the crew were having arms on board the vessel, they thought that is something which has to be established by undergoing a full-fledged trial. So this is a trauma which the crew can face, and in this 4 years, most of the foreign crew members lost their job. To a certain point, the owners were supporting them, but beyond the stage, they also stopped providing any kind of assistance, and therefore, they were jobless, and by the time they reached back to their respective countries, they were finding it extremely difficult to manage their lives. So these are situations which crew can face even without their knowledge.
Thank you, Hari. So this just shows the domestic nature of all these criminal prosecutions, and it all depends upon the law of the country where the seafarers facing such a charge. There was a case recently which I handled where the seafarer he was stopped at the airport because he was carrying egg and pellets, and he wasn't aware that that is prohibited under Chinese law. And that led to a lot of detention, and of course the club and the owners are assisting him. But the struggle that a seafarer has to go through because of the unknowns of a foreign legal system, and especially the criminal justice system, is something that requires a lot of attention. There is also an issue of the media or the criminal prosecution not understanding the complex mechanics of the shipping industry. It's not just the crew, not just the master who is the decision-making authority. At times, machinery, the equipment might abandon the crew. There might be other management and ownership issues that can lead to an incident, and which is more often than not overlooked. At least in the beginning, it takes time to present evidence and take the prosecution through the entire gamut of evidence that they may have. I'll let Kate share her experience on this and the cases that she has handled.
Yeah, so as Apurva, I think, has said both in the introduction and there, maritime incidents, seldom are caused by one factor. They tend to be caused by a combination of factors or a chain of events. If you take one of those events away, perhaps the incident wouldn't have happened, or it wouldn't have happened to the same severity. And there is usually a human element somewhere along the way, often right at the end. It might be deliberate, but it's often an error, sometimes a negligent error, sometimes a criminally negligent error. But I think the focus of this is those cases and the perception that there's a risk of overemphasizing the human elements at the expense of examining the range of causes that caused an incident and the learnings that the industry can take from that. So, firstly, why does this happen? Again, as Apurva has said, there's a real media spotlight when these incidents happen. And firstly, we all know that investigations into these causes can take a very long time. So you might not get the full picture for a year or even two if the matter ends up in litigation, you have experts, until well after the event and the spotlight has moved on. In the meantime, and sometimes with good reason, it is easier and it's also more impactful for the local authorities to take action against the crew. They're in the jurisdiction. As I set out before, if you're in the UK, there are specific offences aimed at seafarers that they may well be in breach of. And on the flip side of that, it is harder to pursue an owner for a criminal offence. Now, in the UK, we have the corporate manslaughter charge, and that actually enables offences to be brought, or charges to be brought against individuals who are in control of companies that have corporate failings that have led to death. However, if the company is outside the jurisdiction, there's an issue of enforcement, and there's also an issue that the industry ownership and control of vessels is quite opaque, and it's quite hard for people outside the industry to understand. And I think, lastly, there is an element of human nature here. We quite like a simple explanation when these media events kind of kick off, and we quite like having someone to blame. And I think it'd be remiss if we didn't talk about the Costa Concordia, which is, I think, the event that brought this kind of to everyone's attention. In case you don't recall, this was a case of a grounding of a large cruise ship off the coast of Italy during nighttime. The immediate cause was that the vessel did a sail-by salute of a small Italian island, actually because the maitre d' came from that island. They didn't have charts, it was a deviation, or they didn't have charts in sufficient detail to be that close to shore. But this was kind of a standard procedure, and it was something that it is reported that the owners quite encouraged. Now, it caused the loss of the vessel, 4,000 people had to be evacuated, and very sadly, 32 people died. The master did not cover himself in glory. No one is suggesting that he wasn't at fault during this incident. And what he's most famous for were his actions after the event. He appears to have gone into shock. He got changed, left the vessel, and refused to get back on. Spent the evening with a priest, inconsolable. So not how anybody would want to react in that situation. But he wasn't actually the only crew member that faced criminal prosecution. 5 others did. They were all allowed to plea bargain, and so on a technicality, they never served any jail time. The owner, after the investigation, which obviously took some time, was fined. They were fined €1 million, and I'm sure you've all got a view on whether that's a large amount of money or not for an incident of this nature, like relative to the cost of the ship. The master ended up being in jail and is still in jail for 16 years. So it was this incident that caused some disquiet as to whether or not seafarers were perhaps taking the blame for everyone. And again, I say in this case, the master virtually put his hand up and said, I will take the blame for all sins. His actions were quite unique. So why does this matter? Well, from a crew's perspective, it obviously matters from a personal point of view. There's huge professional, potentially financial and emotional ramifications and impacts if you're caught up in this kind of incident. Depending where it happens in the world, you're also at risk of not having a fair trial. It really depends on the jurisdiction. We would hope with the case of the Salon, that's a Russian master who's facing criminal prosecutions in England. I think there are good grounds to say he will probably have a fair trial. However, if the situation was reversed and it was an English master and this had happened in Russia, there would definitely be concerns that perhaps that master was not going to get a fair trial. And as a consequence, there are reports that junior crew are actually reluctant to take on more senior roles because of the perceived responsibility, personal responsibility you could have if you're involved in an incident of this nature. And it also, I think, adds to a culture where people are unwilling to put their hand up and say if they see something going wrong. There was a case in 2021 called the UBC Savannah, and that was a vessel that was carrying out cargo operations in Mexico. The master became concerned that drugs might be being loaded on board. He alerted the authorities, they came and investigated, and he was correct. We need to call it a day. I will be very quick. He was detained for 18 months, which hardly encourages the type of hand-in-the-air culture that you want.
That just shows, the blame game theory that goes on after an incident. I think MV Dali was a very recent case which showed the same pattern. Quickly, I'll just take a minute and I'll hand over the mic to Hari to speak about the jurisdictional aspect of criminal prosecution.
I think Enrica Lexi is a classic case which dealt with the issue of jurisdiction. The incident occurred 20 nautical miles from the coastline, and therefore the flag state raised the argument that the coastal state does not have jurisdiction to proceed against the mariners who were involved in the incident. The matter was taken up before the International Tribunal of Law of the Sea, and the tribunal passed an order that until the jurisdictional issue is resolved, the criminal prosecution should be kept in abeyance. But ultimately, the matter got settled and the victims were paid compensation by the Italian government. But such an action was possible because of the strong efforts put in by the flag state. So flag states plays a very important role when it comes to criminalization of seafarers. If it is a flag of convenience state, there isn't much they can do about it or to save the seafarers. But since Italy was involved in it, they were able to repatriate the two mariners when the trial was going on in the country, and then ultimately settle the matter. So as far as jurisdiction is concerned, any incident which all of you know, which happened in high seas, it is only the flag state which has got jurisdiction and not the coastal states. And I think in India, in contrast to the provisions of UNCLOS, we have the Maritime Zones Act, by which the penal jurisdiction of the country is extended up to 200 nautical miles. So that is how the Indian authorities took action against these mariners.
Thank you, Hari. This was quite a popular case in, I think, 2013 or so. But I think what comes out of the panel discussion is that due process of law obviously always has to be followed, and there has to be accountability of the owners, the crew, and I think a lot of cooperation from the owners as well is required to ensure that the criminalization aspect of seafarers is not really taken down the wrong path, and there is fair treatment given to them as per the legal process of the country where they are facing such charges. On this note, I'll end the session, and thank you so much for listening in.